The bank sent 3 men to his farm on a Monday morning. They brought legal papers, a lawyer, and they were smiling. He was 76. He had worked that land for over 50 years. He let them talk. He let them finish. Then he went inside and came back with an envelope. 3 days later, the bank stopped smiling, because that envelope had been waiting there for over 50 years. His name was Gerald Pratt, and he had not come by that land easily. In 1952, his father Raymond Pratt paid $2 for 180 acres of farmland in rural Kentucky. The seller was an old widower named Carl Jessup, a man who had no children, no heirs, just one condition. Someone had to keep working the land. Raymond Pratt shook his hand, and he kept that promise every single day until he died. Gerald grew up on that farm. He learned to work before he learned to read. His mother, Ruth, kept everything together: the house, the books, the family, through droughts, through winters, through years when most people would have walked away, and they never did. When Raymond passed in 1974, he left Gerald 2 things: the land and one instruction. Don't ever let them take it from you. Gerald took that seriously. He married Dorothy in 1976. They built a life on that land, raised 2 sons, put up a second barn with their own hands in 1983. And when the farm crisis hit in the 80s, when neighbors started selling, walking away, losing everything, Gerald stayed. He held on, year after year. By 2024, that land had been worked by his family for over 70 years. Gerald Pratt had never missed a property tax payment, never borrowed against it, never once considered selling. It was his. The way the sky above it felt like his. The way the creek running through the south field felt like his. And for 70 years, no one had ever questioned that. Until the letter arrived. The letter was from a company called Hargrove Capital Group. Not a bank, not a government office, a private investment firm out of Nashville. It said they had recently acquired a portfolio of legacy land assets across rural Kentucky, and through that acquisition, they had identified a claim on 180 acres in Callaway County, the land currently occupied by Gerald Pratt. The letter was polite, almost friendly. It gave him 30 days to respond. Gerald read it twice at the kitchen table. Then he called his son, Michael, in Cincinnati. Michael listened without interrupting. Then he asked one question. What exactly are they claiming? Gerald didn't fully understand it. The letter mentioned an original deed dispute going back to 1948. It said Carl Jessup had never held clear title, that there had been a lien placed on the property in 1947 by a lending institution called First Agricultural Bank of Western Kentucky. And according to Hargrove Capital Group, that lien had never been fully discharged, which meant Carl Jessup had sold land that was never legally his to sell. Gerald put the phone down and sat there for a long time. 2 weeks later, a second letter arrived. This one wasn't polite. It referenced legal proceedings. It mentioned a court filing date. It used the words, unlawful occupation. And at the bottom, in plain language, Gerald Pratt had 60 days to leave the property. 60 days. He had lived on that land for over 50 years, his father before him. His mother was buried on the hill. Under an oak tree she had planted herself in 1955. And now, a company from Nashville was giving him 60 days. He didn't panic. He didn't call a reporter. He didn't put a sign in his yard. He got in his truck and drove into town to find a lawyer. The lawyer's name was Patricia Holt. She was 58 years old, and she had practiced property law in Kentucky for 32 years. She had seen companies like Hargrove Capital Group before. Not this one specifically, but the type. Investment firms that quietly acquired old debt portfolios and then showed up decades later at the doors of farmers, widows, and elderly landowners, with legal language designed to confuse, pressure, and exhaust. She told Gerald straight on the first day, These companies count on people giving up. Most do. Then she looked at him and said, "You're not going to." Patricia requested everything. The original 1952 deed between Carl Jessup and Raymond Pratt, every property tax record going back to 1948, the complete chain of title, and most importantly, she requested that Hargrove Capital Group prove the actual existence of the 1947 lien, not a reference to it, not a mention buried inside an acquisition document. The original lien itself, signed, dated, filed with the county. Hargrove's lawyers responded within a week, confident, fast. They sent a thick package of documents, merger records, acquisition agreements, portfolio transfers, going back through 4 different companies across 40 years. Patricia went through every page, slowly, carefully, line by line. And on page 31, she found something that made her stop. The 1947 lien did exist. It was real. First Agricultural Bank of Western Kentucky had placed it on the property in March of 1947. That part of Hargrove's claim was accurate. But on that same page, just a few lines below, there was something else. A discharge notice. Dated September 1949, signed by the loan officer of First Agricultural Bank, confirming that the lien had been fully satisfied, paid in full, cleared from the property, 18 months before Carl Jessup ever sold that land to Raymond Pratt. The lien was real, but it had been paid off, 3 years before the sale ever happened. Patricia sat back in her chair and looked at that page for a long moment. Then she picked up the phone and called Gerald. "Gerald, I need you to listen carefully. That lien they keep talking about. It was settled in 1949. It's in their own documents. Page 31. Gerald didn't say anything for a moment. Then he said, "So they knew." Patricia paused. That is exactly the right question. Patricia Holt filed her response on a Thursday morning. It was 14 pages long, every page methodical, every argument built from Hargrove Capital Group's own documents. She didn't need outside evidence. She didn't need witnesses. She used their paperwork against them, page by page, line by line. The central argument was simple. The 1947 lien had been discharged in September 1949. Carl Jessup had sold clean land in 1952. Gerald Pratt had inherited clean land in 1974. And Hargrove Capital Group had purchased a claim that did not legally exist, and their own documents proved it. She also filed a separate motion, asking the court to consider whether Hargrove Capital Group had knowingly pursued a fraudulent claim, because that discharge notice had been sitting in their own files, on page 31, in plain sight. The hearing was set for a Wednesday morning in March. Gerald drove to the courthouse alone. Dorothy had passed 3 years earlier. He had not remarried. Michael drove down from Cincinnati the night before. He sat beside his father in that courtroom, without saying much, just being there, the way sons do, when something important is happening, and words aren't enough. The judge was the Honorable Carol Reeves, 19 years on the bench. She had seen cases like this before. Hargrove Capital Group's lawyer went first, polished, prepared. He spoke for 22 minutes, about legacy debt obligations, successor liability, portfolio acquisition law. Judge Reeves let him finish. Then she reached for page 31. She looked at it. For a long moment. Then she looked up. "Counselor, are you aware this discharge notice has been in your client's possession since the time of acquisition?" The lawyer paused. It was a small pause. Maybe 2 seconds, but everyone in that courtroom felt it. He said, "They were still reviewing the full scope of the documentation." Judge Reeves held his gaze for a moment longer. Then she looked back down at the page. And then She ruled. The claim brought by Hargrove Capital Group against the property of Gerald Pratt was dismissed, with prejudice, meaning they could never bring it again. Gerald sat very still when she said it. Michael placed a hand on his father's arm. Gerald nodded once, slowly, the way a man nods when something he already knew in his bones has finally been said out loud. Gerald Pratt walked out of that courthouse into a cold March morning. Michael walked beside him. Neither of them said anything for a while. They just walked to the truck and stood there for a moment, looking out at the quiet street. Then Michael said, "Dad, you want to go home?" Gerald said yes. He drove back the same road he had driven that morning, past the same fields, past the same fence lines, past the small white church where Dorothy was buried. He turned down his gravel driveway, parked in front of the farmhouse, and sat there for a moment before getting out. He walked to the north edge of the property, past the old barn he and Dorothy had built with their own hands in 1983, past the creek his father had shown him how to fish in when he was 6 years old, all the way up to the hill where his mother Ruth was buried, under the oak tree she had planted in 1955. He stood there for a while, just a man, and his land, and 70 years of family underneath his feet. Some things cannot be purchased, some things cannot be taken, by a letter, or a lawyer, or a company from Nashville, with a briefcase full of old debt. Gerald Pratt knew that. Raymond Pratt had known it before him, and the oak tree his mother planted was still standing. If this story meant something to you, share it with someone who needs to hear it. Next time, a woman in rural Ohio held on to her late husband's farm for 11 years against a bank that never stopped coming. She kept every single letter they ever sent her, every one. We'll see you there.